Director of Planning and the Secretary for the Commission. Mr. Secretary, you call roll.
Thank you. Sean Davis, are you present?
I am here.
Talib Horn?
Here.
Shea Collins, are you present?
Present.
Colin Talbert? Here. Present. Robin Allen?
Present.
Devon Babor?
Present.
Victor Clark Jr.
Here.
Mr. Previs?
Here.
And the Honorable Edward Reisinger.
Thank you. We have minutes from our March 7th meeting. Anybody have a chance to review them? I have just two modifications to that. Again, on the first line, it says the 1957th Planning Commission meeting. It's actually the 1961st.
Mr. Chairman, I actually corrected that earlier this morning. I finally understood what you meant because after last meeting I went back and I was looking at the numbers, not the words. So
Okay.
if you reload Wix, it should be correct.
Okay, great. The second one I had was on number 2, approval of the minutes. It says approved, but it was approved as amended.
Thank you.
Does anybody have any questions or comments on that? Do I have a motion? Second? All those in favor? Aye.
Aye.
Any opposed? Any abstentions? Well, there should be one abstention, and that's Talib. You weren't here. All right. With that, let's move on to the consent agenda items.
The first item on the consent agenda are CIP transfers.
There are 3 dates. March 13th has 31 items. Are there any questions or comments? Do I have a motion?
Motion to approve.
Second? All those in favor? Aye. Any opposed? Any abstentions? The March 20th has 6 items. Are there any questions? Do I have a motion to approve? Second?
Second.
All those in favor? Aye. Any opposed? Any abstentions? And finally, there was the March 27th meeting, which had 9 items. Are there any questions? Do I have a motion? Second?
Second.
All those in favor? Aye. Any opposed? Any abstentions? Okay, item number 4.
The final item for the consent agenda is a revised final design approval for signage for Reisterstown Road Plaza, PUD number 111A.
Does anybody have any questions regarding this item? Do I have a motion?
So moved.
Second? All those in favor? Aye. Any opposed? Any abstentions? All right, on to our regular agenda.
The first item on the regular agenda is a street closing of Inlows Alley and 2 3-foot alleys in the vicinity of Park Avenue and West Mulberry Street in the 11th District. Eric Tiso will present.
Mr. Tiso.
Good afternoon. Turn the pointer on, it works better. This is indeed a street closure for Inlows Alley and 2 related alleys. So thank you. Here is the vicinity. This is the block that we're talking about. You see Inlows Alley bisecting that right here. And this is prompted by some proposed development that will be happening in the very near future. From overhead, we've got the here, Inlows Alley is here, and there are 2 related alleys that are in between these buildings here. Looking to the north, the former garage structure has already been removed in this image. Some of them date from just before or just after. For information purposes, the backs of these buildings will be trimmed off, and this larger building and these will all be renovated. And this is looking towards the south. And this one, the former garage structure, is still visible. So for the closure, these are the alleys highlighted in red here. All of them are surrounded by properties that are owned or will very shortly be owned by the future development group. So by definition, because they surround all of them and are consolidating them for their development, these rights-of-ways are no longer needed for public purposes and can therefore be closed. And for that reason, we recommend approval.
Are there any questions? Mr. Tiso. Yes.
I just have a comment. There are utilities existing in the Inlows Alley, but I noted in the reporting that was supplied by staff that that's been recognized as part of the process.
Yes, that was picked up through site plan review.
All right. Any other questions for Mr. Tiso? Is there anyone here who would like to speak in favor of this item? Okay, wonderful. Is there anyone else here who would like to speak in favor of this item? Seeing none, is there anyone who would like to speak in opposition to this agenda item? Seeing none, I close the public hearing. Any further discussion from the commission? Do I have a motion?
Move.
Second?
Second.
All those in favor? Aye. Any opposed? Any abstentions? Thank you. Thank you.
The next item on the regular agenda is a citywide adoption of a design manual update. Christina Hartsfield will present.
Good afternoon, Commissioners. Just to update or refresh your memory, when we last met on February 21st, we had a discussion about the design manual updates, what we're trying to achieve, some of the things that we noticed that weren't working. So we went through this whole exercise of updating the design manual with the objectives to, again, reformat the style, omitting grammatical errors and such, to clarify ambiguous guidelines, updating the content to align with recent amendments to the code, and to add new guidelines for roof terraces and gas stations in certain districts. So where we left off, what we needed to do was to evaluate the comments and update the manual accordingly, add illustration and graphics, add more hyperlinks to enhance the online user friendliness, to publish the final draft for review, and to present to you all for approval. So what we needed to do, again, was to review and respond to the comments. You'll see here, as well as on your Wix site, that these are the comments that were pulled from Civic Comment Online, and the comment was listed in red, and the response to them was highlighted in blue. So we did do that. We also worked on a few more illustrations. These illustrations are not yet in the manual, but I'm presenting them to you today to get your feedback on them, because essentially they illustrate some of the language of the comments, so of the guidelines. So it helps to have visuals to be able to understand what some of the words are saying. These two in particular are about some of the setbacks that were clarified in the standards, and for rooftop decks and also for roof terraces. Here's another illustration that we're adding to clarify what we intend for the facade transparency. We also clarified the language for the commercial ground floor to clarify exactly what we intend, or what we're trying to get to for transparency, because per some of the feedback that we received, it wasn't clear how much glazing was really being requested of the ground floor commercial uses. So here we're illustrating, a typical commercial facade, some of the dimensions that we have in the manual, as well as, what we would hope to see in some way. We also were, one of the suggestions from Civic Comment was to add hyperlinks. It makes complete sense that you would be able to read it online and not have to keep scrolling through, but to be able to click on the hyperlink to go exactly where you want to go. So we did that. And we also published all of these updates back on Civic Comment for public review. We closed the comment period, but we did want the public to be able to see the changes that were made. So in terms of notification, we first posted the draft on Civic Comment on the 4th of February. We had our initial planning discussion on the 11th of February. The comment period closed on the 27th of February, and on the 21st of this month, we published the final draft and the responses to the comments. The public was also notified of these changes and of these meetings through our Compass, as well as through hyperlinks on the agenda. And with that, we are asking for your approval of the updates to the design manual.
Thank you very much, Mr. Thurston. Are there any questions or comments for staff from the commission? Yes, Commissioner.
Thank you, Mr. Chairman. I just want to compliment the staff. I think the manual is very clear, presented well, not a lot of ambiguity, and the illustrations are very helpful. I think you guys have done a fantastic job. I think it's a great document. Congratulations.
Thank you very much.
Any other questions? Yes.
Thank you,
Commissioner
Mr. Chair.
Volpe.
Christina, great work. I do have one question. If you could just go to your slide related to facade transparency. I guess I'm not understanding the relationship between the 5-foot distance, I guess that would be a store shelf maybe,
Yeah.
and the window. I guess I'm not, because that's, to me, separate from transparency of the actual window itself.
Yes, so within the document is further clarified. Here it's just a brief illustration, but more language of the design standard clarifies that essentially we want to have visibility within the commercial spaces so that we can avoid those commercial spaces that will have large windows but then put some type of graphic or signage or put their shelf right against the window so that the visibility to and through the ground floor we can't actually achieve because you're blocking the door or the window. So the 5 feet essentially illustrates that, you know, we should be able to see 5 feet within the actual space. More language is in the actual manual that makes that a little bit more clear. So that's, you know, we say facade transparency. There is a definition of transparency of the glazing, but here we're really talking about visibility.
Thank you. I just want to make sure that we provide opportunities for really creative storefronts, maybe there's some mannequins displaying merchandise.
Yes, sure.
Are there any other questions for Christina? Okay, is there anyone here from the public who would like to speak in favor of this item? Is there anyone here from the public who would like to speak in opposition to this item? Seeing as it closed the public hearing, I think you did a great job too.
Thank you.
And thank you for getting back to me on my comments. That was great. All right, do I have a motion? Second? All those in favor? Aye. Any opposed? Any abstentions? Great.
The next item on the agenda, on the regular agenda, is a minor subdivision with waiver final plans for 1420 Light Street in the 11th District. Matt DeSantis will present.
Good afternoon, Mr. Chair, Commissioners. So this request is a minor subdivision. However, since a waiver is required, it has been placed as a full item on your agenda. So the property is located at 1420 Light Street. The petitioner is Colbert Matz Rosenfeld. The property owner is Roberta Cowley. And this is in our South Planning District with Brent Flickinger as our comp planner. So here is an aerial, or a view of the area. So here's Light Street. Giddings is here and Marshall Street. The property is located right here. So you might recall, so back in, when was this? The September 27th meeting from last fall, there was a virtually identical application for subdivision at 1428. So I think like this property or one of these down here. So if this application looks familiar, that's there. Apparently neighbors talk down in South Baltimore. So zoomed in a little bit more. The red outline is roughly the property bounds. The property is improved with two structures on the property. There's a larger 3-story attached structure fronting on Light Street, and then a smaller semi-detached structure fronting on Marshall Street. So the reason for the waiver is the property is zoned R8. which requires 2,000 square feet of lot area for semi-detached structures. So as proposed, the smaller semi-detached lot contains 820 square feet. So that so therefore a waiver from the commission is required to grant approval of this subdivision. Otherwise, this would be a consent agenda item. So just for some more context, this is the front of the structure on Light Street, and the street view is old. This is from this is the front of the structure on Marshall Street. This photo was provided by the applicant.
By the way, it was a great posting.
Yeah. And
Could have been a little higher.
And the property was posted on both sides of the property.
I saw that.
Yeah. So as no new development is proposed, the existing conditions plan is the development plan. You can see here that the footprint of the larger structure on the fronting on Light Street and the smaller fronting on Marshall Street. And proposed here is a new lot line, which will separate this one lot into two lots. And here's the subdivision plan. An access easement for the benefit of this lot will also be recorded to provide emergency access from the back of the lot fronting on Light Street. So again, the waiver is needed because of lot area requirements. The lot will only contain 820 square feet as opposed to the 2,000 required. But as no new development is proposed and that there's no practical change to the existing conditions of the property, staff has no objections to the granting of the waiver. So, public notice, abutting property owners as well as the South Baltimore Neighborhood Association have been notified, and the property has been posted in accordance with the commission guidelines. So staff recommends approval of the application with the granting of the waiver to create a substandard lot. I'm happy to answer any questions.
Great. Thank you, Mr. DeSantis. Are there any questions for Matt? Marcia, Commissioner Collins.
Chairman. So the area where you're creating a new subdivision line is in the middle of a courtyard area?
Yes.
Is there gonna be any visible delineation, or do the neighboring properties bigger? I mean, how does that?
We have the engineer or representative is here. Perhaps
Well,
Carla could provide
before you do that,
some
just
insight.
stay.
If any fencing or walls.
Okay. Are there any other questions for Mr. DeSantis? Okay, thank you very much. Please, if you would just let us know who you are.
Hello, Carla Ryan with Colbert Matts Rosenfeld. And to answer the question, there's nothing planned to divide the courtyard area.
Does that answer? No fence?
No.
No
fence.
invisible fence? Just very friendly neighbors.
You could survey it. I usually.
Yeah. Till one of them gets a dog. Okay. Is there anyone here who would like to speak in favor of this petition? Is there anyone here who would like to speak in opposition to this petition? Seeing those, I close the public hearing. Any questions or comments from the commission? Seeing none, do I have a motion? Move. Second?
Second.
All those in favor? Aye. Opposed? Any abstentions? Thank you, Mr. Santos. Oh, you're back.
Oh, yes.
The next item on the regular agenda is a major subdivision with a waiver of final plans at 906 through 914 North Broadway in the 12th District. Matt DeSantis will also present.
Thank you, Mr. Chair, Commissioners, again. Subject property is 906-914 North Broadway. The petitioner is AB Associates. The property owner is Harina 906 Broadway LLC. This is located in our East Planning District with Marcella Wallace as our comp planner for the area. So the subject property is, so this is an overhead view to give some context. So Broadway, Ashland, the Hopkins campus to the east. Zoomed in a little bit more. This red dash is roughly the property bounds. The site is approximately 4,995 square feet. It formerly consisted of five 15-foot wide row house lots. The buildings were demolished in either 2006, 2007, and the lots were consolidated in 2016 by the city. Subsequent to the consolidation, the property was sold through the vacancy to value program to the current property owner. So here's, to give some more context, this is a street view of the property from the sidewalk to this supporting wall. The existing conditions, again, it's a roughly rectangular vacant lot. The request is a major subdivision as the proposed lot split is from 1 lot to 5 lots. And additionally, the waiver is required because the land subdivision regs require minimum lot widths of at least 16 feet. But as proposed, the subdivision plan proposes to recreate where the former lot lines used to be, resulting in 15-foot wide lots. So here's the subdivision plan again so this existing conditions plan, this shows where the former lot lines used to be, which coincidentally is exactly where the new lot lines are proposed to be. So it's sort of an unconsolidation with development in a sense. So the subdivision plan includes a private access easement. We'll go to the development plan, roughly the same image. So the elevations, what's proposed are 5 3-story attached townhomes with brick and hardy panel facades. The side elevation is proposed with more hardy panel, the 3rd floor deck, and the rear elevations. The 4 northernmost units include garages. The southernmost unit, there's not quite enough geometry for a garage, so instead a off-street on-site parking pad is proposed behind this unit. So again, the waiver is required again because there's a 16-foot wide requirement. The proposed lots are only 15 feet wide. The proposed lot configuration conforms with the previous lot lines before they were consolidated, and the property was awarded to the applicant by the city for the construction of 5 attached single-family dwellings. So staff has no objections to the granting of a waiver to, in a sense, recreate these 15-foot wide lots. Budding property owners, as well as HEBCAC, Ashland Park Condos 2 Association, and EBDI have been notified, and the properties has been posted in accordance with Planning Commission guidelines. So staff recommends approval of the subdivision plans with the required waiver. Happy to answer any questions.
Thank you, Mr. DeSantis. Are there any questions for Mr. DeSantis? Are there any provisions being made for pedestrian access diagonally through the property post-construction? Because that is probably the most well-worn cow path
Yeah,
I've ever seen.
that's a pretty impressive cow path, isn't it?
Okay. All right, yes, Mr. Collins.
Thank you. So when I was reading the reports, I saw that one of the things they wanted to do was enlarge the tree pits, which is important for the tree survival. But I was getting a little concerned because they seem to be right where we're going to be putting the water lines.
Mm-hmm. Yeah, the message related to the applicant was basically, since the water lines are going to be replaced, to enlarge the existing tree pits to the greatest extent practical. So if the tree pit, if the enlargement doesn't conform exactly to what's indicated here, sort of just the general intent is to expand the wells as much as possible. Since and from the street view, those are some pretty substantial trees in very tiny tree wells.
Yeah, let's look at me, it's not gonna make it.
But
Yes, Commissioner Priebus.
I hoping you could remind me what was required. You know, we have now a completely pervious surface, and we're gonna go to completely impervious. What is it again that's required for stormwater management in that situation?
Yeah, so since the site is a hair under the 5,000 square foot trigger, but when you factor in also the disturbance required for the utility connections, that's going to push it over the 5,000 square foot threshold. The development plans have been shared with DPW, and DPW is aware of the project, and the applicant is aware that they will have to satisfy whichever stormwater management requirements are necessary. Sorry. Yes. So since the lots have been vacant for since 06, 07, the development is considered new development and not redevelopment. Most likely, since there's not much space or no space on site to provide any sort of stormwater management, storage or mitigation, likely some sort of payment in lieu is will be assessed by DPW at time of building permits.
Are there any other questions or comments? Seeing none, is there anyone here in the public who would like to speak in favor of this item? Okay, hold on one second. Mr. Berry.
Al Berry, the associates for the owner developer. Just if there are any questions, city was great to work with on this. We would like to think that a lot that's under 5,000 would be not penalized by replacing the water meters in the sidewalk and redoing the sidewalk. And there's been discussions with the city about that, but we'll deal with that at the building permit.
Yeah, that unfortunately, that's out of the purview of this commission.
I know.
That's something you're going to deal with DPW about. Was the property part of an LDA?
Not, well, the LDA, the award by the city was to replace, I wasn't involved with the negotiations with the housing department, but it was put up for offer by the housing. There was some discussion, could be for apartments or townhouses. My client agreed to do 5 townhouses replacing what was there. It was awarded for that purpose. So
In the
there's no
future, I mean,
LDA.
It's something we should talk with housing about, because if they're disposing of something in this size or greater, then they should take that in consideration of the existing conditions at the time of the disposition. And if it was grass,
No, it was grass at the time of disposition. A number of people, as you might be aware, have raised this with the city occasionally about the interpretation of that stormwater provision that works against the city's clearance program for ultimately new housing. And I wish there was some way that the city would sort of recognize that and not penalize these small projects. Now, if you get the waiver and the in lieu of fee is not terrible,
No.
then it's not that big a deal, right?
unfortunately, it's not recognized by the city, but by MDE. So that's probably the,
But the negotiation, the city should have an MDE rather than.
wouldn't argue with you on that.
I argue with you on that, but I mean, it's not a penalty. We've got to deal with this stormwater thing. It's something that every time we put impervious surface in, we've got to deal with it. So I know what everyone's saying, but it's more complicated than just taking it up with MDE.
Are there any other questions for Mr. Berry? Thank you. Is there anyone else here who would like to speak in favor of this item? Is there anyone here who would like to speak in opposition of this item? Seeing none, I'll close the public hearing. Any additional questions or comments from commission members? Seeing none, do I have a motion? Second?
Second.
All those in favor?
Aye.
Any opposed? Any abstentions? Thank you very much. So we've got like 1 minute before the 2 o'clock agenda starts, and for everybody's edification, we are actually going to switch items 10 with items 9, with item 9, so that the City Council Bill 19-0346 can be heard first, and then we will deal with the aesthetics and design standards for small cells on public rights-of-way adoption. Okay? probably should save that and wait until everybody come in. So we'll be saving that again.
That's fine. I just figured I'd get in position.
What?
Should we have a discussion?
I have few powers there.
Let's do the pros and cons.
Trust me, having, okay, it's 2 o'clock. We're going to start back up. As I mentioned, like 20 seconds ago, we are switching items 10 and items 9 on the agenda. 10 will go first, and then 9 will come after. So, item number 10.
The next item on the regular agenda is City Council Bill number 19-0346, repeal of ordinance 96-032 for the new Lexington Terrace planned unit development. And council members Costello and Bullock's districts, Martin French will present.
Mr. French.
Thank you, Mr. Chairman, members of the commission. This is the request to repeal an ordinance which was amended back in 1998. The original ordinance, 96-032, created the new Lexington Terrace planned unit development on the site of what was then the Lexington Terrace public housing development, which, if any of you do recall, was a development of high-rise family housing, public housing. It was built in the 1950s and ended up being torn down at the end of the 1990s. The petitioners, as mentioned, are council members Costello and Bullock at the request of the Roman Catholic Archbishop of Baltimore. The property owners, the two key ones are the Housing Authority of Baltimore City, the mayor and city council, and then there are private homeowners within the redevelopment site, now known as the Towns at the Terraces. This is in our South Planning District. Brent Flickinger is the community planner. This is a view of the site itself. I'm going to try to use the pointer here. This is looking southward from Mulberry Street. This is the Franklin Mulberry corridor end right here. This is Martin Luther King Jr. Boulevard, which forms the eastern boundary of the site. Then Fayette Street forms the southern boundary of the site, and Fremont Avenue forms the western boundary of the site. This is the development itself, the planned unit development. And as you can see, except for this section right here in the middle, this development has been completely built out according to the plan that was made for it in the planned unit development ordinance. This is a view looking westward. Again, Mulberry Street, Fremont Avenue, Fayette Street, and Martin Luther King Jr. Boulevard. It's a 15.5 acre site. It was used basically to create housing of two types. There's elderly housing in a mid-rise building, and then there is low-rise housing for families bracketed around it. Also to include some non-residential uses, office and retail, and a large daycare center. This redevelopment produced what you see illustrated on here, and it's also mentioned in the staff report you have in front of you. This development basically was created as a residential mixed-use development at the time under the zoning code of 1971. A lot of this could not be done, and so the planned unit development was required in order to make it possible. The new zoning code since 2017 allows residential mixed-use development to happen in a number of ways. It also basically is not something that would prevent the redevelopment of the vacant section you saw for a new school building. And planning staff in reviewing this bill noted these points that essentially this PUD is built out. The ordinance itself is no longer needed for any purpose. And the repeal would also be consistent with our comprehensive master plan objective of streamlining development process. Essentially, there's no need to have an extra review of what's proposed to be finished with the school. And this new educational facility is going to be subject to design review in accordance with the design manual, which you just recently heard about. On that basis, we are recommending approval of this bill. The planning staff notified Towns of the Terraces Association. There was also posting at a number of locations by the applicant, and we have not received at this moment any formal response from any person or organization concerning this bill. That's the end of our report. Any
Thank you very
questions?
Are there any questions? Now, we heard of this similar application for this property, and it was not but 6 months ago, and that was for, what, the disposition?
It was a sale.
It was the sale.
It was a sale bill.
Are there any other questions or comments for staff? Seeing none, is there anyone here in the public who would like to speak in favor of this item? Yes, sir, please come up. Tell us who you are.
Good afternoon, Commissioners. My name is Nolan McCoy, and I represent Archbishop Laurie. I work at the Archdiocese of Baltimore as the Director of Facilities and Real Estate, and it is our plan to bring a much-needed asset to West Baltimore. It is our vision to open up a new Catholic school on this site. We think it'll help transform the west side of Baltimore and provide a muchly needed asset for the community. Councilman Costello did arrange to have community hearing meetings, which I attended, and everyone in the community at that hearing was very supportive of this project. I did bring with me 10 copies of the site development plan. If you wanted to see them, I have them here if you'd like me to hand them out, showing the elevation, the rendering, and the planned use of the property. We intend to work with the community organizations to allow them to use the athletic field, which will also be constructed on that site. When the school is not in use, we would work with organized community representatives where they could come in and use both the gymnasium and the athletic field while we're not in session.
That's
And if there are any questions, I'd be glad to answer them, and if you'd like.
Yeah, if you can give those copies to Mr. Tiso, and he can.
I bought 10 copies.
Are there any questions for the witness? Yes, Commissioner Horn.
Just a comment.
Yes.
Just want to applaud the Archdiocese. This is the first new school in over 60 years that you have done. Appreciate that you decided to do it in West Baltimore. Definitely needs it, and just thank you for your investment.
Thank you very much.
Any other questions for the witness? Thank you very much, sir.
Thank you.
Is there anyone else here who would like to speak in favor of this petition? Seeing none, is there anyone here who would like to speak in opposition to this petition? Seeing none, we'll close the public hearing. Are there any additional questions or comments from the commission? Yes. Commissioner Allen.
I'm not looking for answers right now, so it's just something to throw out. Is there someplace we can get additional, I remember seeing this in the newspaper quite some time ago as a proposal from the Archdiocese, but I'm wondering about things like capacity of the school and so forth. Is there somewhere we can get details like that?
I think actually would be the applicant, so we want to open.
I don't want to hold things up now, I just,
Oh,
I'll just respond to your question. We are going to create a website to have this
That's-
information accessible, and to your specific question, it'll open with a capacity of 540 students.
great. Thank you, sir. Good. Does that answer your question?
I was interested partly because Laurie will know this. Baltimore City Public Schools and city planning looked into putting a school on this site at least 10 years ago. And there was some question about the size. The site itself is not very big. It's deceptively small. So that's part of my reason. But I think it's an excellent idea to have a school in that area and a community asset. So thank you.
I'm delighted that the applicant is reaching out to the community with the opportunity to use the facilities when they're not in use by the applicant. So is there any, actually, we closed the public hearing. Any other questions or comments from commission members? If not, do I have a motion? Second? All those in favor? Aye. Any opposed? Any abstentions? Thank you very much. Good luck. Our last agenda item.
So-
Agenda item number 9.
The final agenda item on the regular agenda are the aesthetic and design center standards for small cells on public rights-of-way, adoption of these citywide, and Matt DeSantis will present.
Mr. DeSantis.
Mr. Chair, Commissioners.
Trifecta for you today.
So, as Mr. Ryer stated, the purpose of this request is to adopt new design and aesthetic requirements for small cell installations within the city's right-of-way, and this is a citywide program. So for some background, and actually prior to this, in the January 10th meeting of this year, I presented a draft version of this document for commissioner questions and input. Since that time, we received comments from the commission, from members of the telecom industry, and we, being planning, the Department of Real Estate, DOT, and our law department, worked together and had lots of meetings, and in order to make some revisions and changes to the document. But again, so the recent regulations issued by the FCC, in particular in FCC 18-133, the declaratory ruling issued in September of 2018, broadly preempt local regulation of small cell facilities within the right-of-way. Our remaining regulatory powers are largely centered on control over the appearance of such installations. These aesthetic standards have to be objective in application, reasonable, and no more burdensome than applied to other infrastructure deployments. There was that order specified that local jurisdictions have until April 15th of 2019 to establish or to publish these aesthetic standards, which is why we are back here today. So again, these are the same context photos shown at the January hearing. These are some examples of existing installations within the city. A couple of these are older designs, tri-panels. This is one freestanding new monopole without any luminaire. There's an example of a more recent installation with by Crown Castle with a 4-foot canister antenna and equipment shroud, and another location existing in South Baltimore. The organization of the aesthetic standards is first a layout of the scope of the regulations, and then a definition section, and then the specific design standards. Much of the substance of the document hasn't changed since this was presented in January. There were a couple changes which I've highlighted and want to point out. If all other things are equal, when an installation meets these standards, it is presumed to be granted by the planning department. Sites will still be posted prior to installation in order to allow for public comment, and engineering review by DOT is certainly still required. And again, just to clarify, these standards are only applicable for installations within the right-of-way. So any sort of wireless telecom installation outside the right-of-way is still subject to standards imposed by the zoning code. So again, just to run through some of these important definitions. Co-location, it means mounting or installing an antenna facility on a pre-existing structure and or modifying a structure for the purpose of mounting or installing an antenna facility on that structure. And when we're talking about small wireless facilities, we're talking about either small cells or distributed antenna system, or DAS, equipment at a fixed location. So these some key standards that they may not be installed within 125 feet of another small wireless facility unless it's co-located on a structure in which a wireless facility is already installed. The intent of establishing this spacing requirement is to avoid an instance where where potentially every single pole on a block, one pole has, let's say, AT&T equipment, the next pole has Sprint equipment, etc. This underlined section, I underlined because we made some wording changes. So a small wireless facility that is installed within 30 feet in the direct perpendicular line of sight from a full-size window on the side of a residential structure may not increase the amount of blockage when looking out of said window. So the initial version back in January spoke about windows from either bedrooms or living rooms, and we had a lot of discussion internally and also with our industry partners, and there was a lot of question about how do you determine what kind of if a window is what's on the other side of a window. So we reworded this to specify any full-size window on the side of a home. So sort of the intent is if you have a end unit row house, this would prohibit the installation of a small wireless facility within 30 feet, looking directly out of the side window, that increases the amount of blockage. So if there's already a pole that's in a direct line of sight, no equipment that further increases the blockage out the window would be presumed granted. And then initially, if there is no pole there, the installation of a new pole certainly would increase blockage. So that would not be presumed to be granted. And then this third bullet point, a small wireless facility may not be installed within 12 feet of a front residential lot line or 6 feet of a side residential lot line. I should have underlined this, but a last minute technical amendment that I am proposing, some clarification and language be added in the versions I passed out to you earlier. Would add language specifying that these measurements would be measured from the perpendicular of the lot line. And this comes as a response to an email from a resident for a existing pole. So again, this clarification amendment is included in the printout provided to you. Some more standards. Small wireless facility may not be installed on a structure less than 14 feet in height or on a structure whose combined height exceeds 35 feet. So again, these are the base parameters. These standards, like all the standards, they're meant to try and be a catch-all. There might be instances where proposals that fall outside of these design standards are acceptable. So in those instances, city agencies would meet with applicants to discuss those unique circumstances in detail. The dimension of a small wireless facility installed in a structure may not exceed 22 cubic feet. So this dimension includes the sum of all associated equipment. The designs or the equipment must be consistent and uniform in appearance and installed to achieve a visually smooth transition between the different attachments. The intent of this standard is to avoid, you've probably all seen some photos of really bad small cell installations where you have a pole and you've got equipment here and you got stuff tacked on here and then here and there. So the intent is to require consistent, uniform installations within our right-of-way. Additionally, small wireless facilities must be the same color as the structure in which it's attached, must be shrouded, and this change, we changed the standard from at least 12 feet to at least 8 feet above ground surface, because we found there's a number of circumstances where with poles that have other signage on them, having a 12-foot requirement for any shrouding is excessive. So this is a good example of some feedback we got from industry partners and a change we've made. So regarding public notice, the As I mentioned, the draft document was made available for the public and presented back on January 10th. These final guidelines were sent out via Gov Delivery to our 13,000 plus email recipient list, and additionally to reps from our industry partners. I'll comment we've received a number of emails voicing objections not to the design or aesthetic requirements in the document, but rather objections to simply permitting 4 or 5G installations in the right-of-way, period. So unfortunately, per the Federal Telecommunications Act of 1996, local jurisdictions are not permitted to deny wireless telecom installations due to perceived health safety risks. The FCC has established certain parameters, and applicants are required to provide evidence and documentation that they satisfy these standards. And if those standards are satisfied, local jurisdictions don't have any authority to deny an application on those grounds. So, yes, it's certainly is understood that members of the public, both in Baltimore City and many comments from outside Baltimore City, have health concerns. The scope and parameters of these small wireless facility design and aesthetic requirements are limited to exactly that, design and aesthetic requirements. So staff, with that, recommends adoption of the I should say, amended small wireless facilities with the amendment regarding the added language for the measurements from the front and side lot lines. And I'm happy to answer any questions. Thank you.
Great, thank you. Questions for yes, Commissioner Clark.
I was reading through the opposition letters, and Beverly Foster says that she had an attachment about microwave lamps. I mean, it doesn't affect what we're doing, per se. It's not legally under our purview. But I would like to see that.
It wasn't included? Oh, okay.
It was not included.
There must have been a technical snafu. I apologize for that. Oh, and I also wanted to comment that in glancing at my email before the start of this meeting, I noticed a number of new emails that came in either last night or this morning to me, to the commission through me, which unfortunately I wasn't able to provide on the WIC site. But I just want to state on the record, were received, unfortunately, just prior to the meeting starting.
Any other questions for Mr. DeSantis? I have a few. So on your staff recommendation, you identify that there are a number of existing 5G facilities that are throughout the city. So
yeah, so there are there's over 600 existing facilities. None of them in the city currently are 5G technology. They're all 4G technology equipment.
Okay, so these regulations would not necessitate a retrofit for those facilities.
That's correct. Any legally permitted installations would not be required to be retrofitted. Any proposed modification or change to them would have to satisfy these standards, however.
On page 3 of the recommendations, the Roman numeral 6, number A small wireless facility must be installed on a structure in the public right-of-way. Does that mean that a small wireless facility can only be installed?
No, I believe that the intent of that line is to specify again that these regulations are only applicable for installations in the right-of-way. Okay. A small wireless facility can be installed outside the right-of-way, but these standards don't cover them. Yeah, it's
What I would
it's-
suggest
it's-
that we do to make it a little clearer is to say a small wireless facility must be installed on the structure when installed in the public right-of-way. Okay. On page 4, a couple of small comments, but I'll skip those. Under S, in a local historic district, a small wireless facility must be screened and be designed for stealth. I hope somebody knows what stealth means, because that can be very interpretive. Okay? And lastly, on page 5, item C, says, a structure may not be installed within 125 feet of a pole that is currently installed, regardless of whether the existing pole is capable of supporting a small wireless facility. Pole is not defined. So I'm trying, what is any pole?
Yeah, I believe that is the intent as drafted. Yes. So and the
Barber pole?
yes. So this would include a city light pole or a BG&E pole installed in the right of way, and the intent is to keep to a minimum pole clutter in the right of way.
Okay. All right, that's all I had. Any other questions, comments from Mr. DeSantis? Thank you very much. Is there anyone here, I'm going to step back. One of the things that's been said, I read through all of the letters that we had received, all the emails that we had received from a number of people, and without exception, all were focused on the health-related issues of this technology. And although I respect and understand your positions, it is not this commission's purview. We have no control under the FCC rules and regulations on how many of these facilities can be installed within our public right-of-way. We are preempted, fundamentally 100% preempted from that discussion. The only thing that we can do is we can control the aesthetics of these facilities should they be located in a public right-of-way. If they're not located in a public right-of-way, these aesthetic guidelines don't apply. So if somebody puts one of these facilities on the roof of a structure outside the right-of-way, there are other design controls that would govern, but none of these. So our sole focus today, and I know it's probably going to disappoint a lot of people who may be here to testify in opposition to this, we can't hear any testimony, we won't hear any testimony regarding the health-related impacts of this technology, because we have no purview of it whatsoever. Okay? Having said that, is there anyone here who would like to speak in favor of this petition? Yes, sir, please.
Good afternoon, members of the Planning Commission. My name is Paul Plymouth. I'm here with my colleague Trey Spear, Government Relations Specialist. We are from Crown Castle, and I'm sorry, my title, I'm a Government Relations Project Manager with Crown Castle. We are the largest shared wireless infrastructure provider in Baltimore City. We currently have about 600 sites deployed in the right-of-way, all helping out with coverage and capacity with everyone's cell phones. We have worked with planning, DOT, the Department of Real Estate, and other various agencies to provide comments and to work on these design and aesthetic requirements. We are happy with what's been sent forth for your vote and adoption today. There are some items that we still think are a little ambiguous, but we continue to work with city agencies to work through some of those concerns. They are nothing major. And one thing that I did want to bring up, since you guys brought up health concerns, with all of our configurations, we file what's known as maximum.
Stop. If it's health concerns, we don't have any control over that. I can't let you talk about it and then say, I'm sorry, those in opposition can't talk about it.
Fair enough.
Okay.
Fair enough. Okay. Yeah, just wanted to say that we appreciate the opportunity to be able to work with planning staff as well as city agencies, and we look forward to the adoption of these regulations.
Okay, great. Thank you. Is there any questions for the witness? I do have one question for you. We are, if the commission so desires, we are going to adopt these today, and they will become the rules and regulations. Now, it's not like a zoning code where you need city council approval to amend them. But as you work through these detail issues, this is fundamentally going to be the standards that you'll be governed by.
Yeah.
So I want to make sure we're all comfortable with that, and it may necessitate future upgrades or updates to this, but, okay?
Yeah.
All
Yeah.
right. Good. Is there anyone else here who would like to speak in favor of this petition? Yes, sir.
Hi, good afternoon. My name is Brian Stover with Verizon Wireless. I'm a real estate manager for the company. We applaud the city and the Planning Commission in taking this action. And we echo Crown's comments that, for the most part, we generally agree with the guidelines. But there's a few issues that we think that the guidelines should really kind of encourage moving the carriers in a certain direction as opposed to restricting or limiting. So for example, with regard to the setbacks, the 12-foot setback from a residential area, is going to create challenges for us. So in the more residential area further out in the city, you have a row of townhouses. Those front yards, those property lines go right up to the sidewalk. So between the sidewalk and the street, you don't have 12 feet. So in front of any of those units, you'd be prohibited from placing a small cell, and should be limited to just side yards. And even I would suggest that 6-foot setback from a side yard, a lot of those side yard setbacks are going to go right up to the side street, and you'd basically be preempting or limiting coverage in those areas. And we're,
This is kind of like a fundamental aspect of this. That this isn't like hey, this is a side issue that we can deal with. That's a fundamental aspect of these rules and regulations. So.
We've met with planning staff, we've provided comments. Planning staff did indicate that these are the guidelines, this is what we want you to do. If you find an area that you can't comply with this, come see us and we'll work it out, and, on a case-by-case basis, maybe we'll say yes, maybe we'll say no. We'd rather see the guidelines a little clearer and, again, encourage us in certain areas versus there's large areas where, in that same situation, that residential area, you may have the pedestrian lights. So I refer to them as UFO lights, but they're 12 feet tall. Right now, you're not allowed to go less than 14 feet tall, but you're also not allowed to go any taller than the existing structures. So again, that would prohibit you from going in that area unless you come in and meet with staff and get a special dispensation.
Well, the scope of the regulations for small wireless facilities there's two. If a small wireless facility installation on a public right-of-way meets the standards expressed in this regulation, the facility will be fast-tracked through planning department and otherwise presumed to be permitted as a matter of right, provided the appropriate permits are obtained and all other requirements are satisfied. So it's a no-brainer. If you meet these setback requirements, great. If the small wireless facility installation fails to meet one or more of these express standards, the proposed facility must undergo a review performed on proposed facilities that have not been fast-tracked and otherwise presumed to have been permitted as a matter of right. That's where you're going to have to come in. And I think it's realistic and reasonable, at least in my opinion, to say, well, they can't go anywhere within the right-of-way, because what happens if that pole's literally right up adjacent to the residence?
Right.
Okay? So I think you have the opportunity under that situation. If you say, no, we really need a facility here, well, come in and let's talk to staff. And you can work it out. Very reasonable staff. So I think that's a reasonable give and take. If you meet these requirements, you're fast-tracked. If you don't, let's chat about it. We can figure out something that's reasonable. But this is, protecting the aesthetic of the neighborhood. My own personal opinion.
Understood, and that's sort of what I said, that we understood that to be the case. What else? Well, I guess generally that's just basically my summary. That again, we applaud the city and the staff for all the work that they put into it, and we'll be coming in to meet with them and review and figure out exactly how to go forward.
Great, thank you very much.
Thank
Are
you.
there any other questions for the witness? Yes, Mr. DeSantis.
Had some comments to supplement Brian's testimony. We've had a lot of very fruitful, positive conversations, and the fact of the matter is, it's a difficult balancing act because the city certainly wants residents to be able to enjoy the services provided by Verizon, by Sprint, AT&T, all the carriers. At the same time, we want to protect to the greatest extent practical the aesthetic of our public rights of way.
Yeah.
So it's with a city as diverse as Baltimore is, it's very difficult to craft regulations that apply,
Uniform.
from Federal Hill to Ashburn, right? I mean, so this is our best attempt to try and put basic parameters, and again, we are happy and eager to meet with any applicant to sit down and work out and find solutions for challenging neighborhoods and
Yeah, I mean,
tough design solutions.
I can literally see in our smaller, more granular neighborhoods where, this might be the right location for a wireless facility, but that pole is right in the middle of the front bay windows of the adjacent row home. You say, okay, well, if you go down the street 70 feet, it's at the common property line to those, and that's much less offensive. Those are the kinds of things that just need to be worked out in detail with staff. So.
And things are changing so fast, both the legally and also technologically. Equipment being installed, now a year ago maybe didn't exist.
Mm-hmm.
So, we could see 6 months, a year from now, we could have brand new technology that looks very different. We'll have to sit down and take a look at these standards. As you mentioned, this probably will be, an evolving, living document. So we're looking forward to engaging
And that's why it's good that they're guidelines kind of housed here with the planning commission, so you don't have to go through some legislative process to have them amended.
Agreed.
It's a much straightforward process. Yes, Mr. Collins.
I just want to point out that we're talking about the rights of way. There are still private property options that carriers have.
Sure. Yep.
But we do, it is important, and in those tight areas of communities, they don't want to be staring into structure and blocking their views. So there are just some things that we have to take into consideration out of respect for our residents. So I hope you understand that.
Yes, ma'am. Thank you.
Thank you. Is there anyone else here who would like to speak in favor of this petition? Is there anyone here who would like to speak in opposition to this petition? And I ask again that if you can focus your discussion on the guidelines that we're presented, not the health-related issues. Yes, ma'am, in the back. Hi.
My name
Your
is
name?
My name is Peggy Williams. I work in Baltimore City, and I'm an environmental scientist, and I've been doing this for over 30 years.
Yes.
I've been doing this for over 30 years. I'm an environmental scientist, and I work in Baltimore City. I can't talk about the health effects. I was going to, but let me just say, I think that's doing a disservice to Baltimore City residents and workers. So I'll talk about what I have left. The primary obligation under the Telecom Act's intent is to provide protection of public safety and property, okay, for the people in Baltimore, okay? These structures have been known to decrease property values to up to 20%. So that's something to think about too. These people are not going to be happy to have structures on their properties right outside their windows, okay? Now, and so the last thing I have to say is that Baltimore must not approve any small cells or their associated equipment, since the FCC order, which cannot in any case override federal law, may yet be overturned as a result of the ongoing lawsuit brought by over 100 municipalities, of which I thought Baltimore was one. Therefore, any limitation of discussion presuming approval of 5G equipment is not only untimely, but given the very stated intent of the Telecom Act, ultra vires, meaning outside the law. Thank you.
Thank you. Are there any questions for the Witness. No, I've read your emails from our January meeting, and again, here, and I understand and I appreciate and respect what you have to say. It's just, again, we're not in the position where we can preempt the federal government. Are there any other, anybody else here who would like to speak in opposition to this? Yes. Ma'am? Yeah, you have to.
Can I say one more thing?
Sure.
My statements constitute no mere matter of concern or other non-substantive matter, but rather matters of substance, okay, which must be considered by city officials. Thank you.
Thank you.
My name is Kate Keel. I also was here to talk about many aspects of this deployment, including health. But I do want to say regarding the Telecommunications Act that apparently, and I haven't seen the document, this is word of mouth by somebody who has studied this quite extensively. In the early 2000s, San Diego, the city of San Diego was taken to court by Verizon for prohibiting or whatever a cell tower on the grounds of health. And in the final results, the court sided with Verizon. But in a footnote, it said, regarding the Telecommunications Act, this, I don't know the exact words, but concerns cannot be considered because they are irrational, health concerns, because they are irrational.
Okay.
But it did not say that health effects or health science cannot be considered.
Ma'am, I'm going to ask you if you can focus your comments on the aesthetic rules and regulations that we have before us today.
So, but what I'm saying is that it may be, in fact, illegal to prevent the public from weighing in or for you to not consider health. That's what I'm saying, officially. So I have a few questions about the aesthetics. First, a few questions just about the process. I don't feel it's been very transparent. I had a very difficult time trying to find the recommendations and trying to understand how this whole system works, because most cities, it's the city council that hears the ordinance and so forth. And it wasn't until this morning that I actually was able to get my hands on the documents. I didn't know until yesterday where the hearing would take place. But again, so that didn't allow me.
For the record, it's important you know, I sent you those guidelines. It was me who emailed them to you.
When?
This morning.
Yeah, at 8:40.
Okay.
I did get them.
They have been posted on the planning department's website.
Where is the planning?
I'm sorry?
January.
Yep.
I didn't know, I still don't know today what the planning department's website is. So,
It's pretty easy to get to. It's just Baltimore City Planning. And if you Google Baltimore City Planning, it'll come up.
regarding the FCC ruling 18133, it is being contested. So if you get locked into these aesthetic guidelines, what are you going to do if that ruling is overturned?
Then we'll change the guidelines. The reason these have been promulgated and why we're hearing them today is we have to have them in place by April 15th under the current law.
I understand you had 3 months.
And if that law changes, then obviously our recommendations would change and respect whatever is decided through any lawsuits that are subsequent to the adoption of this. And these, as I said earlier, these are guidelines. This is not an ordinance, okay? This is not an ordinance which would require city council approval. These are guidelines, and they will be housed like our landscape guidelines, like our architectural guidelines within the planning department.
Okay, because the lead law firm for the joint opposition for the cities and the U.S. Conference of Mayors said motion of stay of FCC 18133 is warranted, relief may be possible. The orders may eventually be overturned. We believe there are substantial questions as to whether the FCC sell order is valid and lawful. We are not recommending that you incorporate these FCC rules into local law. If you do, then you will be bound by your own requirements, even if the FCC order is vacated.
We are not bound by them.
Okay.
These are guidelines that can be modified by this commission at any time.
Okay, so what these guidelines, what do they do about the Americans with Disabilities Act if somebody has a verifiable condition of electromagnetic sensitivity? What will be done to accommodate them?
I have no idea.
Well, how do we move forward on that? Because that is a federal law and it trumps state or local law.
It is nothing, again, that's a health-related, what you just brought up was a health-related issue, not an aesthetic issue.
No, it's
Okay,
not
we
a
can,
health.
we can split hairs on this, but
It's a legal matter, it's not a health
absolutely.
matter.
I mean, we have to abide by ADA throughout everything
Okay.
that we do.
Right, so how are these aesthetics and the ordinance abiding by the ADA?
They're mounted off the ground a minimum of 8 feet.
Well, that doesn't help because the radiation is going straight into somebody's bedroom window. I am personally,
That's health-related, ma'am.
no, it's not, it's legal because these people are living in their cars. They're living in their cars because they've been they've had to leave their homes from this stuff.
Okay.
So it's not a health. I'm not contesting the health. I'm saying these people have a verifiable condition that's recognized by the U.S. Access Board as a disability. How are they going to be accommodated if you stick a cell tower right into their bedroom window?
That's the purpose of the regulations, was so that it wouldn't be right in their bedroom window. Yes, Mr. Tison.
Mr. Chair, as this is, technology is evolving fairly quickly, and these guidelines were developed with input from our law department. If there was a specific concern under ADA, we would seek their advice, and we would have to grant whatever reasonable accommodation might be done. For certain existing locations, we have had facilities moved because of concerns, so I think that would remain a possibility.
Okay, thank you.
And how would the person with this disability affect this change? Where would they go?
Excuse me.
They should notice us.
Can I address
Oh,
your
I'm sorry.
questions to the commission?
I'm sorry. Just how does a person with an ADA disability, an electromagnetic sensitivity disability, deal with that in light of the current regulations being considered?
I guess they would have to raise the question potentially to their council person, who would then probably raise it to staff within the various departments, whether it be planning or DOT or whatnot. That's the only way. I mean, if they know a direct line into the planning department or any of the agencies, then they can raise it there.
And if they say, I cannot live in my house with this, if they say to their council person, then how does that go?
Yeah, that's where you would challenge. It's a great point.
What?
I should say that's where you would challenge any ADA requirement, whether it be sidewalk
Right.
Capabilities. So
And then the city council person takes it up with the planning commission, or?
I
You
don't
don't
know the
know.
process from that point. I mean, technically, it would have to be a legal challenge, I would imagine, where the resident would have to say that this is impacting me from an ADA and bring suit against somebody. Yes, Commissioner, Councilman.
As a council person, I would basically refer it to the law department.
Right.
Get their opinion.
Yep. Yes, Mr. Tisa.
One more thing.
We're going to stop this in 1 minute, just so everybody knows.
Certainly, one more thing to add. Another avenue where concerns are frequently raised is the Mayor's Commission on Disabilities.
Yeah.
We have a representative that works with our site plan review committee, so there's multiple avenues where a concern could be brought to us, and we would handle it from there.
Good.
A few more things I was wondering if they were considered. I will say them right now. Yeah, so question if that should be incorporated into the ordinance something with the ADA issue, so people know how to proceed with that. A lot of cities, Petaluma, for example, has a 1,500-foot minimum spacing between small cells. So wondering why Baltimore City couldn't do something similar.
I would imagine it's because of the technology in this particular city. That's the only reason I can give you.
Well,
And by the way, I think that 1,500 feet would probably, sounds to me like a location issue of how many you can have and where. And again, it's our opinion that we are preempted from deciding how many. We can only say where in relationship to other things.
do the wireless carriers have to prove a significant gap in coverage before sticking one of these things up?
Not that I know of. But
Why-
at the same time, why would they overlap so greatly that they're expending money unnecessarily?
Not really. They do this consistently. To just slap up more coverage for no reason. So that might be something that's considered, to get a significant gap, proof of significant gap before that. What is the written notice for the perimeter of the small cell facility? In other words, homes 3,000 feet away, 20 feet away have to be given notice?
Yeah, it's a posting requirement at the specific site,
And there's no,
I'm sorry, how many feet? On the pole.
Yeah, the posting is placed on the pole, or if it's a new pole, like a stake is placed at the location. It's posted for a minimum of 2 weeks.
Okay, thank you.
and the people in the perimeter don't get personally notified by mail or an announcement in the papers?
No.
No, that's not the case. So currently, there's over 600 installations in the city. There are, it appears to be over the next couple of years, thousands more applications. So to provide written notice to all property owners for every one of those, it would be administratively, I don't think it would be feasible. Additionally, our city council members are also provided notice of proposed locations.
Great, thank you.
Well, if it's not feasible, that might be reason to contest the FCC order. If it's not feasible to give everybody warning, it just seems due process. And a number of other communities, a lot of other communities in the country are saying all equipment other than the cell tower, other than the antenna, should be undergrounded. Is there some reason why Baltimore City doesn't say that? Aesthetically, it's a whole lot better to underground all this stuff.
No.
Why do we not do that?
Okay, Mr. DeSantis?
Sure.
There's a lot of things going on underground in the city.
Yeah, we discussed with industry partners and with our other city agencies and the legal department. We talked about a requirement for undergrounding equipment, but the reality is, with a city like Baltimore, to require undergrounding for all equipment in probably half the city. It's our built urban fabric is so dense, it's so old. There's so much stuff under our right of way, which there active lines that we know about, abandoned lines we don't know about. To require installations to be underground, it would be an unreasonable request. That's what I recall our legal department
You got to go
expressing.
back to your original comment in your staff report that basically says, make sure that I get this right. Here, but, that they can be no more onerous than I'm looking for the specific language where they can be no more onerous than any other utility location.
I think in here, the third point.
Right, aesthetic
Objective-
standards need to be objective in application, reasonable, and no
Reasonable.
more burdensome than applied to other infrastructure.
I think we'd have a very difficult time proving reasonableness of an undergrounding requirement in the city.
Although other cities are doing that around the country, so.
Okay, maybe they have better or newer systems in their underground. This has got to be the last question.
Are you going to, again, other cities, Petaluma and a few others, I believe, have have no cell towers, no small cells allowed in residential areas whatsoever, and a 500-foot setback in mixed-use areas. Is there some reason that Baltimore City cannot emulate that?
Where is Petaluma?
California.
Okay, I mean, what kind of density are we talking about here?
Don't know. Never been there.
I mean, is it a suburb or is it?
I don't know.
It's not a city.
I'm not familiar.
Okay. All right. Okay. So.
In any case, what their jurisdiction does or does not do, our law department hasn't reviewed, and we can't presume that what they're doing is not ripe for challenge either. So it's our understanding that this complies with the laws that are in place at this time, and these were promulgated with our law department, so your mileage may vary.
Okay. I have to, unfortunately, ask you to yield the mic to the next person who would like to speak. But for the record, are you a resident in Baltimore City?
I am still a resident of Baltimore City.
Perfect.
I'm moving. The closing of selling my house is in 4 days.
Okay.
But I'm currently still a resident.
Perfect, thank you. I hope everything goes well with your closing.
Thank you. And I'm moving out because of this.
Okay.
I'm moving
Well, I'm
out to
sorry
the
to hear
country, and my daughter, I'm separated from my daughter, who's also moving out to get away from this.
Okay.
And we both have to be separated from each other. I'll say one more sentence. This is a quote from Professor Heroux, who's a professor of, he's an expert in this field and a professor at McGill. It is perfectly possible to design the fastest telecommunication systems while minimizing health impacts. First, give the highest priority to deployment of optical fiber networks to home and businesses, which can ultimately be far faster than 5G. Second, capitalize on wired connections, which, like cable, can bring speeds of 10 gigabytes speeds to second to homes. Third, recognize cell phones for what they are, a radiating device, redesign them to minimize user exposures, which can result in reduction by factors of 100, and use them sparingly rather than letting them become a substitute to workstations and the home of eye candy.
Thank you very much. Is there anyone else who would like to speak in opposition to this? Yes, sir. Again, if it goes onto the health side in any way whatsoever, I'm stopping it.
Let me introduce myself. I'm Dr. Robert Marcus. I used to head up the rheumatology program at Baltimore City Hospitals, and at the time this was under the Schaefer administration, and Larry Reich was a good personal friend of mine. So I have a tremendous respect for all of you people, but this is the first time I've had a chance to appear in front of the body. So I live in Highlandtown in the 300 block, and I've been first of all, I think you guys are being bamboozled. I realize this has nothing to do with the aesthetics, but I think what I have to say, I want to go on public record. I've had to put up with the DSL line from Verizon, and I've pestered them for years to get fiber optic there, and I'm strung along. And this in spite of the fact that I've been a long-time customer as well as a Verizon stockholder. They give me, they keep on pushing me up the ladder. And it's clear that the way to go with communications is fiber optic.
Sir, we're here to talk
I know, but I want this information here. I'm only going to take a couple minutes.
All right.
Just hear me out. It's secure. It's more secure. It's faster. We'll forget about the potential risk. But the question is, my question to you is the Planning Commission, what are you people doing in terms of pushing for fiber optic communications in the city? Boston has had a similar problem, and I'm suggesting that you touch base with your colleagues in Boston and see how they have handled it. It may require some federal government intervention, but this is clearly the way to go, especially for a planning commission.
Thank you.
Thank you.
Is there anyone else who would like to speak in opposition? Yes, ma'am. And then sir, and then ma'am.
Hi, bear with me because I've had a horrible cold for forever. Hi.
I'm sorry to hear that.
Okay.
And please stay over there.
I will try to speak so you can understand me. So, my name is Sue Ackerman. I am a gardener. I have a background in plant biology and insect physiology. Okay. I don't know what category you're going to think this is in.
Let me guess.
These were some things that occurred to me that maybe might be interesting to people. The Earth's brain waves, or natural magnetic frequency, is about 7.83 hertz. There are 64 elements in the Earth's which balance these magnetic frequencies. We human beings contain these 64 elements in our red blood cells. There's a natural resonance between all life on Earth and the Earth's pulses or magnetic fields. The combined electromagnetic fields coming off a standard electrical outlet is about 7 to 10 times that of the natural magnetic frequency of the Earth. Okay. Earth's magnetic field, about 7.8
I gotta stop you.
hertz. Cell phone signal
Ma'am.
is 2.7. I will
Ma'am.
skip down here. It says, I was going to talk about honeybees and birds.
I'm
Okay.
sorry.
I'm not going to
I really
continue to
appreciate
speak
your
about the
passion. I
current
appreciate
information we have regarding the safety of wireless devices. Although the industry continues, much like Big Tobacco has done, to sell us the wonderful new things to be done with 5G tech, while promoting fraudulent research, ignoring precautionary measures, and creating the impression that there is doubt regarding the findings of danger. The industry has already admitted that they are unable to prove that their technology is safe.
Okay. Anything to discuss regarding
I
the
would like to
aesthetic
quote
standards?
Victor Turgola of
Ma'am.
Baltimore City.
Is there anything to deal with aesthetic standards?
Yes.
Okay, please proceed with the aesthetic standards, no quotes.
Okay. Okay, somebody recently stated in the hearings in front of the General Assembly, State of Maryland, she said, I'll paraphrase it.
Okay.
How can we come up with real policies as opposed to guidelines and ordinances that disenfranchise us as citizens? What are the true needs of a community in the area of communication tech? Would we not prefer the kind of aesthetic from our city government that helps plan and design a healthy, ethical, and non-warlike communication system for everyone, not one where we are drawn into technical surveillance, chaos, and war by a few global wireless energy hogs? And I did see that Mr. is it Turgola? Turvala, who is, I believe, the city solicitor and law department. He did say this. He says, the 5G carriers are asking you to do what basically Congress would not do. They're basically asking you and taking your zoning. He said, they're taking our zoning away from us. That was Victor Turvala, Baltimore City.
I sincerely appreciate your passion, and everybody here who's here today for your passion. It is simply outside the purview of this commission to address the issues that you would like us to address. I strongly recommend that you would speak to your state legislature and your federal legislatures so that they understand your passion. But we are here regarding a very simple discussion on aesthetics, and I thank you.
And it will come down to not just passion or concern, but it will come down to the implementation of actual law that is just.
Thank you.
For all of us. Thank you.
Yes. Next, sir.
Commissioner, my name is Roderick Calloway, former Army aviator in Maryland National Guard for over 10 years. Electrosensitively disabled, but I can't talk about that, so we won't go into that. I'd like to ask the Commissioner if he was aware that November of 2018, the FCC spoke to a Senate committee chaired by Senator Blumenthal from Connecticut. Are you familiar with that, sir?
No, sir.
Okay. Well, during that testimony, the FCC made the statement that 4G currently and 5G potentially is safe. Okay? And he required the FCC to send them documentation to his office saying that it is safe, whether it be scientific data, whatever. That was in November of 2018. I've been in touch with Senator Blumenthal's office as of 20 March 2019. That data has yet to appear. Now, if the data was there, one would think that it's mere effects. 20 minutes, 20 seconds, it would be there. So the FCC has declined to provide proof of the information of their statement during a Senate subcommittee hearing. Now, I know this filters down, and I understand you can't connect, but if the FCC can't prove that it's safe, then I thought it would be under the purview of all of the states and the cities and the counties and the leaders thereof to make sure that before you implement something, that you find out whether or not it's safe or not. And if it isn't, there are alternatives. You heard the alternatives. Okay? This lady has to move out of her house out of Baltimore. I have to move. And representation of the citizenry requires a responsibility. And we hope that it won't come to the point where 10 years down the road, as in the cigarette scenario, we find that decisions made by the local representatives were not, in fact, in favor of or support of the citizenry.
Thank you, sir, and thank you for your service. Is there anyone else who would like to speak in opposition? Okay.
By the way, that's when you file an ADA complaint, it's the Department of Justice Civil Rights Division, Disability Rights.
Yes, please tell us your name.
Hello. My name is Pamela Harris, and I've been an environmental professional for over 20 years. I would like to comment on the City of Baltimore allowing 5G to be installed throughout the city without the appropriate research, restrictions, and public disclosure.
All right, I'm going to stop you right there.
Okay, I understand.
I mean,
the
if you
restrictions.
have specific
I do.
comments regarding the ordinance.
I do. Okay.
Please.
Other
I mean,
communities
regarding
around the
guidelines, it's not an
country
ordinance.
are fighting hard to prohibit or at least restrict their installation by prohibiting them in residential areas and setting rigorous setbacks for aesthetic reasons as well. Petaluma, California requires a minimum 500-foot setback
It's a nice place.
from residential homes. Fairfax and Mill Valley, California prohibit 5G in residential neighborhoods altogether. Burlington, Massachusetts has a comprehensive recertification process. Little Silver, New Jersey ensures homeowners are notified within 500 feet of an installation. Walnut, California, a wealthy community, bans towers within 1,500 feet of a school, park, or residential area. How is this not an environmental justice issue? Why does the city of Baltimore not give its residents the same respect that these other municipalities have given theirs? Do our residents matter less than those that live in Walnut, California? Is the city of Baltimore going to be like the tobacco industry, looking backwards with 20/20 vision? This is a time for Baltimore to step out ahead of the pack, like some of these other locales, and say no. You want to bring residents and business back to Baltimore. DC, Philadelphia, Pittsburgh have improved their aesthetic value. Baltimore has not. To attract residents and to do right by the community, please reconsider. Thank you for your time.
Real quick question. Do you reside in the city?
I work in the city.
Where do you reside?
I reside in Baltimore County.
Okay, thank you very much.
Thank you.
Is there anyone else here who would like to speak? Yes, please.
I do have a question. This is not.
Please tell us your name.
Mary Callan, and I live in Baltimore County, but I do a lot of business here in the city. I know we're not talking about health, so I'm not going to talk about that. I'm not even going to talk about the environment. What I am going to talk about is this. We know that the planning committee and taxes, would you say they go hand in hand?
I'm sorry?
The planning committee and taxes, would you say that goes hand in hand?
The planning commission. I'm
Yes,
going to say commission.
planning and taxes, would you say that goes hand in hand?
I'm
Think
not
about
gonna-
it, you plan a house, you build a house, you tax the house, am I not correct?
I'm not going to go that far, no.
Okay, you're not gonna go that far?
No.
So if I build something on my property, I'm not gonna get taxed by the city or the,
Well, yeah, of course you are. But
all
that
right,
is not-
so planning and
Excuse me,
that
if you let me
goes hand in
finish,
hand.
I'll let
Okay.
you finish. You
Yeah,
let
I'm
me
getting
finish.
there, okay.
If you
So-
build something on your property, it's because of zoning. Zoning allowed it.
Just hear me out on this, okay?
Okay.
All right. Now, here's the thing. The thing is that you're talking aesthetics. People don't want the aesthetics. The aesthetics aren't really protecting people. It's just there to, you're trying to make it look pretty, if I'm not mistaken, right? You just basically want it placed somewhere so it can look pretty. Oh, look at this new tubular thing instead of these pads or whatever. We need to get up and running. But what happens to the property tax? The property taxes do go down on the property when you put stuff on it, especially things like utility poles, any type of small cell, anything that is not put there to have value is going to decrease the property value. Now, with that property value, would you not say that the taxes would actually go down because of that? Would it go down? And if it does, that means less money, because money seems to be an issue here in the state, okay? Would that mean that that you would get less money in taxes because of the aesthetics that you want to put there? Would that happen? And how would you recoup that funds, or recoup the funds for that property in which you put that aesthetic on? I mean, everybody's talking about windows and everything. That's fine and dandy. We know about, all the health stuff. But how would you recoup that money?
Oh, do I get the answer now?
I hope so.
Oh, okay, great. So
I'm
first.
trying to be quick because everybody else will, take time, and I know how I've been watching you. So.
Okay.
Okay.
So I don't think there's any evidence whatsoever that property values go down because there is a small cell device in the front of that, in the front of that property. If you can
Now,
provide such evidence, or if anybody can provide such evidence, that's great.
Okay.
You've had your opportunity to speak now.
Okay.
Okay? So, but if it did, you gotta weigh that with the overall community benefit. Okay?
What's the benefit?
If we collectively have said that we want to be, a community, a city that is technically advanced, is providing opportunity for all of our residents, a variety of different things, then that's a goal or a focus of what we have to accomplish.
Really?
Yeah, we do that every day. We make choices every single day.
So, but who's making the choices? Because I'm not making that choice.
Sure you are.
No, I'm not. I didn't say I wanted this in my, I mean, right now, from my home, I've seen a tower go up further and further, which I could not see. But now it's going up further and further. We call this thing like an ultra tower now, because they're adding more things to it, more pads to it, more cells to it, whatever you want to call it.
Okay.
Okay, that's not helping anybody. I didn't ask for that to happen. So how are you saying this is benefiting me? I never said I wanted it. Nobody came to my door and said, I want this. Do you want this? So how is this benefiting me when I know I know we're not talking health, but I know the health implications from it, and I know people who are dealing with it. I'm not right now dealing with it, but I know people who are dealing with it, okay? They're not in this room, okay? So knowing what I know, knowing what NIH says, CDC says, knowing what all these things say, even the World Health Organization, despite all that, I don't want that thing. I'm pretty satisfied with the cancer cell I already have, which is 4G. Okay, I don't want any more. All right. So how can you say that this is benefiting me? This is not benefiting me. This is hurting me.
Well, I'm sorry we disagree, ma'am.
Yeah, I know. But what are you guys going to do about it?
Well, we're looking at the guidelines that are before us to help the aesthetic as best we possibly can.
Okay. Let me ask this question when it comes down to that, and I'm going to go sit down. You keep moving the guidelines. I keep hearing you from back there that you changed the guidelines. So, yeah, we'll just change it. If this change, if that law change, if they do this, then we'll change the guidelines.
Right.
So, I mean, that's not a guideline. What is that?
They are guidelines. And as technology changes, guidelines change. That's the reality of it.
Do we have an option as far as what we want? We the citizens, we that pay the taxes on the property that you want to put the cell in front of, do we have an option to say no? I know we don't. We're an FCC state, but, what are you guys going to do to fight that? Who's fighting on our behalf?
Elected officials.
Yeah, I mean, I would absolutely talk with your elected official.
Yeah, that don't get nowhere. I'll be down in Annapolis. But anyway, thank you so much for your time.
Thank you for your
Appreciate
time.
what you're doing. I understand that your hands are tied and you can only do what you can do. I'm just bringing this to your attention that there's a lot of us that just don't want this, and I'm not bringing the health into it just because of the fact that we know what it is. Okay?
Thank you.
Thank you.
Yes, it's being recorded right now. It's all public record. Is there anyone else who would like to speak in opposition to this? Okay? Has she spoken before? Okay, great.
Never spoken in front of a hearing in my life before. Okay, and I don't know what I'm going to say except that.
First, your name.
Let me say this. My name is Geraldine Bell. I reside in Baltimore City. I own my home, and I've lived there for 40 years, since 1973. It's not about health. Okay, I have done everything to, my house is, I'm on my computer a lot. It's hardwired so that it's not with the Wi-Fi, because when I had it for 3 weeks, I got so sick and headaches, and I've read the literature, I've read it, I've studied it in depth. For me, there's an issue, and I know a lot of people. When this 5G, the small cell towers, go close to my house, I won't have any choice. I'll walk down the street and I'll feel it. And my house is, it's a row house. From here, there's the front street. I'm going to have it in my house whether I want it or not. I'm not given a choice. I'm ready. If I could, I would move out of the city tomorrow, because if this is the way it is, all over the world, cities, municipalities are speaking up about this. The Wi-Fi is being torn down in some cities and some countries because they see the effects on kids. They're using hardwire to use their pads, to use all of it. There are fewer and fewer, there aren't the people left. They could see people who smoked and didn't smoke back in the 50s, 60s, and 70s. There aren't going to be people who don't use this wireless technology. There will be no controls. Other countries are looking at this. Some countries are banning it. Many cities are banning it. I have here, it's very simplified. It's several, some of it's a few years old, but there's some resources here that Environmental Health Trust has put together a lot. What is 5G and the internet things? Kate Keel has put together a lot of information for different kinds of technologies. There are groups all over the country in different cities, world, that have banned. These are scientists, Doctors Against radiation, doctors against, it's not, you say it's not about the health. My God, what's it about?
No, I'm not
And,
saying.
and are you being bamboozled? We don't have a choice. You haven't given, this is, I think there's 10 of these here. At least
I gotta
there's,
stop you right there. So let me
this
say.
is wrong.
No, hold on a second. I'm not saying you have to step down from the mic. I'm just saying, it's not that we don't have a choice. We don't have a choice in terms of the location. We are, as a planning commission for Baltimore City, preempted by the Federal Communications Commission on locations of these devices.
Others are fighting back.
And-
Other
and-
municipalities are
and
fighting
if
back.
the city collectively chooses to do that, great. If the state collectively chooses to do that, I'm not seeing
Then how do
Baltimore
we make the
County or
city,
Anne Arundel
how do we
County-
ask the city?
Ma'am,
Who gave you
in
the?
fact, excuse me. I'm not seeing Anne Arundel County, Baltimore County, Howard County. I'm not seeing any of those jurisdictions fighting back. They're experiencing the exact same things that we are. Okay? So I'm not seeing any of those jurisdictions. I'm not seeing the state fight back.
It's because they're so involved in so many other things that are of concern, huge concern right now, from on high, that
So
we are being right and
don't
left
have,
things are
we
being
don't have
ripped
the
up.
ability to say no. What we have the ability to do, no, we don't. We absolutely don't. We have the ability to say, if it's going to be here, you got to follow some standards.
Money
you
was
don't-
given for fiber optics. Grants were given, and I read this, it's documented.
This is not about fiber optics, it's about the aesthetic
But it was
standards
given, the
or-
money was there for fiber optics to do what's being done. This has been in the works for years and years and years, and money was given for fiber optics to go forth with this. And then the telecommunications, yeah, they decided against that. It's going to cost more for them or something. I'm not sure why. But that's not, I feel like, have you guys done your research? It can't be just about planning where it's going to be. You have a voice too.
Okay.
You represent us on some level. Somebody has to represent us.
You're
Because I don't
represented-
want to have to move out of the city. I don't know what I'm going to do.
You're represented at your city level, at your state level, and at your federal level. And I strongly suggest that you address these concerns to the people who are on the legislative side who can effectuate this, not on the commission side who deal with guidelines.
So you're going to go ahead and put it up, and then if they
I'm not
come
going to put
forward-
anything up.
The
What
planning
I'm going to say
commission.
is, if you put something up, you got to follow these standards. And if the laws change and the FCC comes back in and they say, no, we're not allowing this anymore, then we'll change. Okay? But right now, we are preempted from saying no to cell companies. We can only say, if you do it, here's the standards you got to abide by. Okay?
I feel like we're being bamboozled by the telecom.
Okay, well, I'm sorry you feel that way.
Yeah,
Is there anyone else here who would like to speak in opposition to this? Seeing none, I close the public hearing. Okay, there's a lot of information to review and discuss. Do we have any questions or comments from the commission back to staff based on the public hearing?
Mr. Chair.
Yes, Mr. Barbour.
A couple of comments. I've heard a lot this afternoon. I do want to thank the public for coming out this afternoon to express your concerns. One, I just feel the need again to stress and emphasize what our chair stated. We are not in a position to supersede federal law. Again, we are not looking at the FCC regulations. We're here trying to protect, to make sure that we are preserving value, preserving the aesthetics of the neighborhoods. And so these guidelines are intended to minimize disruption as much as possible. Two, for those of you that are interested in the city's technology strategy, I encourage you to go to the city's website. We have a fantastic new technology director. The city has released an inclusive digital transformation strategic plan, so take a look at that. You can see all of the ways that the city is moving forward to advance the city to make us really a 21st century city.
Thank you for
In terms of aesthetics, again, this body, this commission, we absolutely care about aesthetics. Earlier this year, we adopted new signage regulations. Earlier in this meeting today, we adopted citywide design regulations. And here, this is another act where we're following up on that work by really trying to make sure that we have parameters in place, again, to minimize the disruption of those towers, which are federally regulated, not by the local level. And then finally, I heard a lot of references to Paloma, California, so I just wanted to share that this is a city of 57,000 people. Thank you.
Anything else from any other commissioners? Yes, Commissioner Clark.
I just want to echo what Commissioner Barbour is saying. I'm a citizen representative, so when I'm not sitting here, I'm sitting there. And I applaud all of you who have taken time out of your busy schedules, which I'm sure a lot of you have, and the time and energy just to come down here and say something about it. Now, as far as strategy is concerned, this time would have been well spent at the FCC meetings. Okay, so if you're doing it all, you're doing it right. If you're fighting the regulations that the FCC demand that we follow and that we do, then you're on our side. We're doing what the law says we can do and have to do as far as design standards are concerned. It's just that simple. So it's not being overly aggressive to say to you, we don't need to hear the health issues. In fact, I was glad to ask the question and get this information because I was in the fog about it. I don't know a 1G from a 5G. I was born when you had desktop phones, okay? You had 3 channels on the TV. You couldn't stream everything that you wanted to do wherever you are, okay? So the world changes. However, when it comes to health, that never changes. And that's what I was saying. What is this they're arguing about? What can this do? People always ask me, you don't have a Bluetooth. I say, well, I think there's something wrong with having something stuck in my ear all the time that's coming through, an electronic piece. Not that I don't know, but it was just common sense that told me to say that, okay? I applaud you. I think you did the right thing as citizens of Baltimore City to voice your opinion, but I would love for citizens who come to this commission meeting and voice their opinion to at least hear what it is we have to do and voice their opinion about that. Even though they may have 2 or 3 subsections to it, they need to understand this is all we can do. We're voting up or down whether or not the design standards, the height and so forth of the things that are coming can be done a certain way. And as Chairman said, it's not an ordinance, it's just guidelines. And if things change, we can change the guidelines. A lot simpler than you can change an ordinance, okay? So thank you very much for coming down, and here we go.
No, I'm sorry, I'm sorry, ma'am, the public hearing is closed, okay? Are there any other comments, questions from the commission? Yes.
I just want to respond. Commissioner Clark I believe, was out sick when we had an in-depth discussion about this. We raised questions about all of the things that you all have brought forward, and we discussed them in depth. We asked questions, we got answers. In the case where the answers were not immediately available in our first briefing, they were brought back to us after research and communication with other entities. So this is not just brought to us cold and we are voting on it and considering it without any background. Please trust.
Are there any other questions or comments from the commission? Okay, do I have a motion?
Second.
May I make one suggestion to that motion to approve with the proposed amendment on page 3, section 6A that we talked about?
Yes.
All wireless facility must be installed on the structure if it's installed within a public right-of-way.
As well as 6D and E, with adding the language about